Welcome, everyone, to House Judiciary. It's Tuesday, January 12th, I believe. Might be the 13th. Yep, the 13th. And we're going to be looking at H 578, an act relating to penalties and procedures for animal cruelty offenses. And we're going to start off with sponsor of the bill, Emily Krasnow.
Hello.
A little too high.
Oh, yeah, I'm a little short.
No, I don't, it's not you.
Oh. Is that better?
Yeah.
Okay.
No, I went up a little bit.
Oh, you did?
Yeah.
All right. Hello, everyone. So I am here today to
You can introduce yourself.
Oh, yes, right. Representative Emily Krasnow, South Burlington, Chittenden 9, for the record. And I want to thank you for the opportunity to testify today. I'm here today to introduce H 578, a bill that strengthens Vermont's response to animal cruelty and ensures meaningful accountability for those who cause harm. I grew up in Vermont, raised by a single mother who, despite many challenges, always made room in our home for animals in need. Dogs, farm animals, rescues. There were times when we had as many as 6 dogs at once. Each one was family, and each one deserved safety, care, and dignity. That upbringing shaped my understanding of animals not as property, but as living beings worthy of protection and compassion. It also shaped my belief that how we treat animals reflects who we are as a community. Unfortunately, not all animals are afforded that care. A case in Orange County illustrates why stronger laws are necessary. On April 9th, an animal owner was arraigned in Orange County Superior Court in Chelsea on 2 counts of misdemeanor animal cruelty after pigs on her property were found emaciated and suffering from malnutrition and cold exposure. A veterinarian determined these conditions resulted from prolonged starvation and inadequate care. After their rescue, the pigs were placed with the Merrimack Farm Sanctuary in Charlotte, my hometown, and we'll hear from those folks later, where they are now recovering through a careful rehabilitative refeeding program and behavioral support. Last year, we saw another disturbing situation in which a dog involved in an abusive case was returned to its owner. After public attention grew, the owner launched a GoFundMe campaign, effectively profiting from the public's concern for the animal. This highlights a troubling pattern. Animals are sometimes treated as spectacles rather than beings in need of genuine protection. Now, before I continue, I also want to highlight, I know that this bill has a bestiality provision, and I want to talk about why that was added into the work that I had previously worked on. I woke up one morning reading about a case just down the road from me in Williston that had me so shaken and disturbed by the case that I felt compelled to add those pieces in. I was just so repulsed and disgusted. As we talk about bestiality, and we'll hear more from others about this component, we talk about in the modern age that we're in now, how animals are being exploited in that way on the internet. So the updated provisions, which we'll hear from Legislative Counsel about, were added after that case, which according to research, and you'll hear from other folks, is not abnormal and has been on the rise across the country in the age of the internet. So that component, but I was just so repulsed and moved to act and felt like that needed to be added to the short form bill that I had talked about last year, that we just cannot, as a society and a state, continue those kinds of abuses and not talk about them. As I mentioned, animals cannot advocate for themselves, and their silence must never be mistaken for consent. We have to be their voice. This bill strengthens Vermont's animal cruelty laws by ensuring timely intervention, strong enforcement, and humane outcomes when animals are abused and neglected. And you'll hear more about what this bill does from legislative counsel and other witnesses. Animal cruelty is rarely an isolated issue. It often exists alongside broader patterns of neglect and violence that affect both animals and people. Preventing cruelty protects communities, not just animals. So I urge you all to support this bill. This is not only about animals. Again, this is about who we are as a society. Animals cannot stand up and ask us for their protection, so we must stand up for them. Thank you for your time and consideration, and I can answer any questions that the committee has.
Any questions for Representative Krasnow?
Thank you, and I look forward to listening to an afternoon of testimony from some really incredible witnesses who are the true heroes on the ground doing the work.
Thank you.
Thank you.
Thank you. Next up, we got Eric Fitzpatrick from Legislative Council to do a walkthrough.
Good afternoon, everybody.
Good afternoon.
Nice to see you. Eric Fitzpatrick of the Office of Legislative Counsel, here, as the acting chair said, to do the walkthrough of the committee on H 578, which is an act relating to penalties and procedures for animal cruelty offenses. I'm going to repeat something I said during our introductions earlier in the session. You may recall that Michelle and myself are covering some bills that were originally worked on by Ben. We're not part of our portfolio, so we had kind of a short ramp up on several topics. And as you would expect after I would say something like that, animal cruelty, it happens to be one of those topics. It was one that I have picked up since then, so there may be, scratch that, there will be more instances where I may respond to a question by saying, very good question, I'll need to go look into that. As you know, sometimes I say that anyway, but I notice that possibly would be a little more frequent than usual because this is a relatively new topic to me as well. So I shouldn't say as well. You folks have been dealing with it longer, more recently at least, than I have. So with that said, the big picture of what we're looking at with H 578, as you could take away from the title of the bill, I think, is that it's related to penalties and procedures for animal cruelty offenses. Now, that means criminal offenses, right? I mean, I think the committee knows that the subject of animal welfare is dealt in a number of different places across Vermont law. It's not just in the criminal code. You have a lot of things in public safety. In Title 20, for example, you may recall just last year, you created the Division of Animal Welfare along with the Director of Animal Welfare, all in Title 20 within the Department of Public Safety. You have things like rabies and vaccinations and wolf dog hybrids and licensing, all these things that are covered in Title 20, not is a topic that this bill is addressing. Agriculture, another place that there's a lot of regulation of livestock, poultry, eggs, that sort of thing, all covered in Title 6. Again, not what is being addressed in H 578, because this is dealing with the criminal penalties. Yeah, and that's within a specific chapter in Title 13. And the criminal offense is actually generally divided up both in terms of a list and by separate statutes into animal cruelty and aggravated animal cruelty. Those are the two crimes that we're going to be talking about today. And familiar concept to the committee, whether it's simple assault and aggravated assault, or sexual assault, aggravated sexual assault, human trafficking, aggravated human trafficking. That concept, I think, is very familiar to everybody, that either by definition and by sort of a graded system of penalties that distinguishes between sort of what we might call, the statute doesn't say simple animal cruelty, but I'm kind of going to use that today just so you know which one I'm talking about when I say it. So, and those distinctions are similar in the existing law. So you've got simple animal cruelty, you've got aggravated animal cruelty. They're distinguished by lengthy lists of what type of conduct is prohibited. You got a long list of prohibited conduct that would be animal cruelty. You have another list of prohibited conduct that would be aggravated. There's some crossover depending on what some aggravating factors might be, and there are different penalties as well. So for simple animal cruelty, is a misdemeanor. It's a 1-year misdemeanor for a first offense. It's a 2-year misdemeanor for second or subsequent offenses. Generally, there's even the penalty statute, frankly, is a little complicated. So there's a couple of carve outs for that too. A couple of different situations where something that you think, well, wasn't that in the simple animal cruelty statute? Then how did that get to be a 5-year felony? Well, we'll leave that aside for the moment. But generally speaking, if it's simple animal cruelty, it's the misdemeanor. And generally speaking, if it's aggravated, it's a 5-year felony, 10-year felony for second or subsequent offenses. So you see pretty steep penalty differences between the simple and so with that kind of as the background, well, what does H578 do? And I'm going to say 3 primary things that I see within the bill that are sort of making changes to the structure that I just described. So number one, as I was just saying, and I think Representative Krasnow is kind of alluding to this as well, that there are lengthy lists of the types of conduct, the types of prohibited conduct that will constitute either simple and aggravated or simple animal cruelty or aggravated. One of those lists, one of those types of conduct that's prohibited is sexual conduct with an animal. And I'm not going to do that right now because we'll look at the language of the bill in a few minutes. But just to sort of say up front, and again, I think Representative Krasnow alluded to this as well, by its nature, there's going to be some somewhat graphic descriptions that you'll see in the statutory language. As this committee knows very well, that sometimes happens in other statutes that you look at as well, sexual assaults statutes, the pornography statutes, that sort of thing. And it's really a constitutional requirement in the sense that it's a matter of due process that people have to be informed with reasonable notice of what conduct is illegal. If you're going to put somebody in jail or subject them to a fine, matter of due process is there at least to have to be some reasonable notice. You can't tell people afterward, hey, that was illegal, you're going to jail. There has to be some notice provided. And for purposes of these sorts of crimes, when it's a very particular type of conduct that's prohibited, the statutory language is very specific. This is what is illegal. This is what can subject you to prison time, essentially. So that's a little just interesting, right? I was just talking about notice on my part to you guys that the language is going to be graphic in that sense. But so what's the change? What the bill change number 1 is it expands that definition of sexual conduct for purposes of sexual conduct with an animal, expands it in a few different ways. A couple of the primary ways are one, so that involves sexual conduct that takes place in the presence of a minor. So that's one big picture thing that's going on in the presence of a minor. And the other one is visual representations of the conduct. So if you think about it, the underlying conduct, the act, is illegal already. This adds to that list a visual representation. You could think of it as, you've seen that before too, in the pornography context, in the child pornography context. Same idea. It's not just the conduct, it's a visual representation. I think that's the artificial intelligence internet aspect of it that Representative Krasnow was referring to as well. So those two things get added in, but within the big picture of these 3 changes. Change number 1 expands the definition of sexual conduct with an animal for purposes of the crime. All right, that's change number 1. Change number 2. What I'm just talking about and what I just referred to are really the criminal sentences of incarceration, right? That as the penalty for this misdemeanor or felony, depending on the crime. That's something that's required if someone's convicted of one of these crimes, whether it's simple or aggravated criminal assault. You've got this sentence of imprisonment and or a fine that is required part of the penalty. In addition to that, though, under existing law, besides the incarceration, there's a number of other sanctions that the court is permitted to impose. And I say permitted because it's discretionary, not required. So there's 5 that they're in this list. For example, the court can say, in addition, hey, you're sentenced to 6 months in jail, whatever it might be, there might be a prison sentence, but there's just other things that the court may do. One is forfeiture of the animal that was subject to the abuse, right? And actually, you'll see in the language, not only forfeiture of the animal that was subject to the abuse, it's forfeiture of any other animal that the defendant owned at the time of the abuse. So but that's not required. It's discretion. Court can do that. Court can also impose what's called costs of care. So if you think about it, let's say you had this criminal case going on, law enforcement seizes an animal. There's going to be some time that passes between the seizure of the animal and whenever it happens to that court case down the road. Maybe the person's convicted, maybe they're not. But during that period of time, the animal is typically in custody somewhere, being held by someone. So it's accumulating costs, what's called costs of care. So that's another thing that the court can do. If the person gets convicted, they could say to the defendant, I'm going to enter in the order, you're responsible for this cost of care that accumulated during that period. So that's another thing the court can do, another sanction they can impose. They can also impose, education and prevention measures for the person. They can require that the person be prohibited from possessing an animal in the future. Not just then, not just an animal they may possess at the time of the crime, but in the future. And they can also, the court can also require that the person be subject to sort of unannounced inspections in the future as well. But each thing that I just described is discretionary, not required. So that's change number 2. Those discretionary penalties become mandatory. The may becomes a shall. So everything that you just heard me list, it's not a matter of discretion for the court anymore. That also, and again, this is the precondition is that the person got convicted, right? Person gets convicted, these things the court also has to impose as a sanction. So that's number 2. So we got expanding the definition of sexual conduct. We have changing from discretionary to mandatory, these other sanctions that the court imposes if somebody gets convicted. And now we have big picture, what else is going on in the bill, number 3. And this has to do with, we're talking about this criminal proceeding just now. In addition, also in the same area of law, there is what's known as a civil forfeiture proceeding. I think the committee has heard that talked about. In fact, I think there's some members of the committee who've introduced bills on this very topic in the past, generally not specific to animal cruelty, but there's other places in the law, motor vehicles with respect to DUI or drug paraphernalia with respect to drug offenses, or it's just part of this general principle that instrumentalities of crime are subject to forfeiture, generally speaking. So this one is in statute currently, that there's also an opportunity for a humane officer to bring a civil forfeiture proceeding. So this is separate from the criminal proceeding against the defendant, the owner, right? This is a civil forfeiture proceeding, kind of a legal fiction, but the defendant is the property. In this case, it would be the animal. So that's who the proceeding is brought against. And it doesn't result in any criminal conviction on the part of the owner. It's not against the owner in any way. But the court is permitted to find. If the court finds, and again, because it's a civil proceeding, it's a lower standard of proof. It's not beyond a reasonable doubt. The court finds by clear and convincing evidence that the animal was subject to animal cruelty. Well, then it can order forfeiture of the animal, right? So that's all existing law. So what's the change? This goes back to change number 3. It creates this. Oh, and so think about that. It's the same sort of chronology that I was mentioning earlier with respect to the criminal proceeding. Imagine if, and under the existing law, this humane officer has the right to seize an animal if they have probable cause to believe that the animal is being subject to cruelty. But again, if they seize the animal, it's going to take a while for that even in the civil context, for that proceeding to go along. So there's this period of time there where the animal is being held in somebody's custody. It could be a humane society, a care organization, whoever that may be. Again, costs are being accumulated during that time. Under current law, if the court orders forfeiture of the animal in the civil proceeding, there is a way to get at some of those costs. The restitution unit has the authority to go after it in the same way they go after restitution orders in criminal proceedings. So they have that authority. But this adds another tool in the toolbox, so to speak. It's called a custody of care action. And so it creates this action whereby the state or the custody care organization, so whichever organization had custody of the animal, can bring an action directly against the owner for the costs. So it creates this statutory action that person can bring and say, we're not going to wait for the restitution unit to go try and get the money from this person. We're not going to make the humane officer foreclose on a lien, because that's another thing that the statute creates a lien in the favor of the humane officer for the costs of care. Also allows this other method to recover that money. Direct action by the organization or by the state.
I guess I'm confused why they can't do that now.
They, in theory, could, but you are making it express. So you're making it much more without any doubt, because it would have to be some sort of argument that there's an implied right of action, right? And that's it might well be, but that's unpredictable. You've made it predictable and clear and exactly what the standards are, what has to be shown, how the process works. So you're right, it may well be, and it's a policy choice for you, whether you want to have it laid out in statute or not. But I think that's the idea behind it, is sort of predictability, certainty, that sort of thing.
Yep.
So those are your three things. Big picture that goes on in the bill. The expansion of the definition of sexual conduct with an animal, the making alternative sanctions other than imprisonment mandatory rather than discretionary, and creating this cost of care action that the person can bring to recover the expenses that somebody incurred while the animal was being held pending the resolution of the civil case. So that's a big picture. We can look at the language a little bit, so sort of see where the details are, but I could pause for a second too if anyone has any questions about what the big picture description does.
Before we get into the bill, anybody have any questions? Representative Arsenault?
Thank you, Eric. I just want to understand the third change.
Right.
And that it only applies in the case of, in civil.
Exactly.
So,
Exactly.
that significant. I
Well,
guess maybe when I learn more about the.
In theory, in theory, because think about there's sort of a connection here in some sense. Remember the cost of care under current law, let's say in the criminal context. So let's say the proceeding goes along, the person gets convicted. Under current law, remember the court has the discretion to order that they pay costs of care. But the proposal is to make it mandatory. So at least I think one way you can sort of envision how this might be working is that, okay, in the criminal context, it's now being made mandatory. The court has to order it. So
This is sort of a complementary change.
it's in the civil context.
Yeah, okay,
Right.
thank you, that helps.
Yeah.
Representative Rachel?
So I've got a question for you that's tangentially related. We charge for care for other things pending trial, like for example, a child abuse case, or I'm trying to think of another time when there's something that requires cost to provide care.
Mhm.
Or is this unique to the animal world?
I don't know the answer to that. It's an interesting question, though. So that is, thank you for allowing me the opportunity to say, I'll look into that and get back to you. So yeah, I'm not 100% sure, but it's an interesting question. So we'll see if there's maybe other statutory, schemes set out that allow for that.
And I assume when we walk through the bill, we'll hear like its usual and customary charges that are charged. So,
Oh, right, from the witnesses, you mean? Yes, I think the
right.
about that. Yeah.
So if I opened up an animal care place and I wanted to charge exorbitant rates, that wouldn't be reimbursed.
Yeah, I think actually the statute does use the term reasonable costs. So yes, exactly. That's sort of built-in limit in that way.
I have a question about the cost of care. Is that something that's reimbursed after the fact, or something that they're paying for to maintain ownership of the animals, like a bond and forfeiture law, or is it more of getting reimbursed after the long court proceeding?
Heather, if you don't mind, you'll be testifying a little bit, and maybe you could bring up your questions then. Thank you. Any other questions from the committee?
All right, so let's take
Floor is yours.
Yeah, thank you. Thank you. And so let's skip to section 2 to start with. And we're going to come back to this definition in a moment, but I just want to sort of lay out what I talked about in the very beginning. You'll see section 2, page 2, excuse me, line 15. Excuse me, that's cruelty to animals. That's the misdemeanor offense that I was describing earlier. So starts on line 16. You see that line: a person commits the crime of cruelty to animals if the person, and they have this long list: 1, 2, 3, 4, 5, 6, 7. I'm over on to page 4 now. 9, 10, 11. Actually goes all the way over onto page 5. So there's a lengthy, as I said, lengthy list of types of prohibited conduct that constitute misdemeanor cruelty to animals, mostly. Because there's a few, again, I'm going to skip the details, but there's a couple of places where some of these in the list get referenced as felonies as well. But for the most part, these are your misdemeanors.
This is the existing law.
Correct. It's existing law. And also, let's continue with the existing law. Go over on to page 4 now. Line 11, subdivision 11, line 11. Engage, you see that one? So this is the long list of things that are simple cruelty to animals. Engages in sexual conduct with an animal, right? So it's already, that's existing law, that's prohibited, and it's a misdemeanor. And then it lists with under that other offenses all related to sexual conduct: possessing, selling, transferring, purchasing an animal with the intent that it be used for sexual conduct. That was B. C, organizing, promoting, conducting, aiding, abetting, or participating as an observer in an act involving any sexual conduct with an animal. So all these different types of conduct connected to sexual conduct with an animal. And you've got A, B, C, D, E, F, so 5 of them under current law. Obviously begs the question, okay, because it doesn't say so here, what is sexual conduct with an animal? And for that, you have to turn back to definition on page 2. And this is the specific description of what actual conduct, and by that I mean, connection between a person and an animal, their body connections that actually do count as sexual conduct. And the proposal is to add 2 to that list. See that? So the existing laws A and B: any act between a person and animal that involves contact between the mouth, sex organ, or anus of a person and the mouth, sex organ, or anus of an animal, right? B, without a bona fide veterinary animal husbandry purpose. Important qualification there, because there may be a reason for veterinary reasons or whatever that sort of contact might be taking place. The insertion, however slight, of any part of a person's body or of any instrument, apparatus, or other object into the vaginal or anal opening of an animal. Again, existing law. So the proposal is to add 2 more, C and D. Without a bona fide veterinary or animal husbandry purpose, person touching or fondling a sex organ or anus of an animal, either directly or through clothing. Or D, any intentional transfer or transmission of semen by a person upon any part of an animal. So expands the definition of sexual conduct, and that is connected to, turn ahead again, page 4. That term sexual conduct appears 1, 2, 3, 4, 5, under 1, 2, 3, 4, 5, under 6 different offenses there, A through F. So for purposes of those descriptions and prohibitions, your sexual conduct definition gets expanded. So that's one change. Change number 2. Sorry, go ahead.
Same person.
Just want to make sure I'm on the right track, but any intentional transfer or transmission of semen, that won't get bogged down with the artificial insemination of like cows and stuff like that, right? You know what I'm saying by that?
Yeah, I do. And
Is that the animal husbandry clause?
yeah, but interestingly, the clause is not present in D. So it's an interesting question that it possibly, and I'm going to leave that to people who are more expert in that type of procedure than I am.
It's not a policy thing. I'm okay.
Right. No, I think you should at least consider, and you hear from your witnesses, whether or not you want to, in response to the point you raised, Representative Grossland, take that language on line 8, without a bona fide veterinary or animal husbandry purpose, and repeat it at the beginning of subdivision D. Anybody see that? Now, it may be, I don't know, maybe there'll be a reason you'll hear from witnesses that shouldn't be done, but as a reader, I have the same reaction. You might want that. So worth flagging and thinking about for later.
Thank you, Chair. Eric, I just have one question. And
Yeah.
At first, let me just say I'm fully supportive of the legislation. But one question I had is page 3, line 1, and it talks about like the manner in which that we're interpreting the behavior of animals being inhumane.
Mhm.
And so like and not to digress, but I think anecdotally, right, there's an instance that I'm thinking of in my own district, right, where there's a small property just on the outskirts of town with probably like no more than a dozen horses in a very small residential neighborhood. Do they look well cared for? Sure, but is it in the best interest of the animals to be in a small confined space where there's a dozen of them? So I'm curious of like, and granted, this is my first time going down the rabbit hole of animal welfare law, but like, what is the barometer of welfare and humane treatment, and like, who decides that?
I was just curious, as you were raising that question, because I didn't know the answer off the top of my head. So I thought, I wonder if either of those terms, either inhumane or humane treatment, were defined in the definition section, because the full definition section is not repeated in the bill, because we only reprinted the definition that's being changed. But as it happens, they're not anyway. So I know I sort of had a false lead up there, right? Because everyone's thinking, oh, there's going to be a definition. Turns out there isn't. So in response to your question, I'm just double checking to make sure I didn't miss it in case it is there. Don't see it.
You can get back to me. I just was something that came in my mind because I go on this walk in my town nearly every single day. And I think about this so it's very timely and topical that we're discussing this because it is something that I think about actively.
Yeah. And I think that I will get back to it, but I think that if the term is not defined, then it's possibly has been developed in case law, but ultimately the arbiter of that is the jury.
Yeah.
Now, it does that, in sort of the idea behind the jury is you have the common standards of things like that. And whether or not in civil case, 6 or 7 of them might agree, it's going to be your arbiter ultimately of whether it's humane or not.
Yeah. And again, like I would never want to dilute the purpose and intent of this specific conversation, but it is something that food for thought.
Yeah.
Thanks for me.
Yeah. All right. So I think that takes us over to page 5. Remember, under existing law, there were these 6 different types of offenses that come under the sort of the subject heading of conduct with an animal. And then another proposal related to sexual conduct is to add this G language on the top of page 5. I mentioned this earlier. Remember, this is the visual image piece. So you possess, film, or distribute visual images of sexual conduct with an animal. Again, the sexual conduct definition is one we just looked at, so it gets roped in there in another place as well. That's the proposal.
One,
Please.
Thank you, Chair. Maybe we're building up to this, but this includes artificial images created by artificial intelligence.
Yes. Yeah, exactly. Now, what's going on? Now, the next section of the bill you see starts on line 3 of page 5, aggravated cruelty to animals. So this is the felony, right? So this section has to do with felony conduct. You'll see there's 3 existing pieces to the felony language now. Often, actually, in each of those involving intent. So it's talking about killing an animal, intentionally causing the animal undue pain, intentionally, maliciously, without just cause, torturing, mutilating, etc. So what this does is it proposes to add, essentially, in fact, exactly, the language that we just looked at for the definitions of sexual conduct on page 4, that line 11, those A through F. See those? That's existing law. What this does is it repeats that language in each of the instances starting on line 12 and subdivision 4, A through F on the next page. But it adds with the minor as a participant. See that?
I'm just looking at line 10 and 11. That sort of looks messed up for some reason.
I think what that means, that's an existing language, but I think what that refers to is basically intentionally killing a law enforcement officer's service animal. Exactly, canine. That's what I was looking for. Yeah. So he intentionally injures or kills an animal, and this is referring to the animal that is in the performance of official duties. The animal is while under the supervision of a law enforcement officer.
Okay, yeah, I got it. It's just worded funny to me.
Yeah, well, I know it is.
Okay.
It takes a couple of times for that
got it.
sentence to see where it's going. So what this does is it adds this exact same language as you have in A through F, but it just adds the language, in the presence of a minor or when a minor is a participant. And in those cases, it's a felony. See that difference? If it doesn't involve the minor, it's a misdemeanor because that's under your standard cruelty to animal statute. If it involves a minor, it's a felony. One thing I noticed, and I don't know if this, it possibly was intentional, this is another one I'm just flagging for you guys, you may want to ask witnesses, is that the new G on the top of page 5, this is the new piece about visual images of sexual conduct with an animal. That is not on the aggravated list. At least I didn't see it. In other words, the aggravated list only goes through F. Doesn't add the new offense in the presence of a minor. So maybe that was intentional, or maybe it was an oversight, but I just wanted to mention it so that the committee might want to consider for purposes of consistency. Everybody see what I
So you
meant?
say that 4A isn't included?
No, I think for A through F, pages 5 through 6,
Yeah.
are all exactly replicate the existing A through F on page 4, lines 11 through 21. So that, except that it adds in the presence of a minor. You with me so far?
Yeah, yeah.
But the new G on the top of page 5 about the visual images with an animal, that is not added to the aggravated crime if it's done in the presence of a minor. Maybe that was intentional, maybe it was an oversight, I'm not sure. I'm just pointing it out so that the committee can ask your witnesses.
Yeah. Probably have some discussion on that going forward.
Yeah, I'm sure. Yep. All right, so we're moving on to, so that's the sort of the end of the sexual conduct, animal cruelty piece of the discussion. So pause there for a moment if there are any more questions on that topic. All right, so now we're moving on to number 2 of our big picture. What's the big picture thing? And here, remember, we're talking about making these discretionary sanctions mandatory. That's not the criminal, not the incarceration piece of it, not putting in someone in prison or criminal fine anymore. Now we're moving on to these other possible sanctions. So you're looking at, you start at page 6, degree of offense, sentencing. So that's all has to do with the sentencing and the sanctions. And you'll see that subdivision 1 there. That's talking about generally some of the particular 5-year felonies and others, or whether they are misdemeanors or felonies. But turn for a moment over to page 8, line 9. And that's subsection B. Everybody see that? It starts, in addition to any other sentence the court may impose. Everybody see that language? So this is a list, and then you see below that, you see, well, looking at first, just see numbers starting on my tongue. You got 1, 2, 3, and then over on the top of page 9, 4, 5. So what that is saying is under existing law, in addition to any other sentence that we're talking about, that 1-year misdemeanor, 5-year felony, whatever it may be. In addition to that, the court may impose any one of these other sanctions. There's 5 of them listed there. And so what is the first change that you see in the bill? Line 10, line 9 and 10. What's the word change there?
Made a sham.
Made a shall, one of our favorites. It's such a small change, but has such significance. So that's the proposal. These 5 other sanctions that currently are discretionary for the court are made mandatory. Court shall impose these. So, and that's the big picture change of what's going on here. But, you know, to see what are these 5, I mentioned them at the beginning, but it's just so to refresh our recollection, because there's a couple of changes within a couple of them as well. So number 1, line 12, forfeit any rights to the animal subject to cruelty. So that's one thing the court would now be required to do, and to any other animal, except livestock or poultry, owned, possessed, or in the custody of the defendant. Everybody see how that works, right? So that becomes mandatory.
Sure.
Yes. Tom?
Oh, I'm sorry. Go ahead.
Except livestock?
Right.
Why?
I don't know. Good question. I don't, not sure the rationale behind that. So this would not be, now that's, remember, this is not referring to the animal that was subject to the cruelty. That part of the language is another animal that the person owns at the time they were convicted of cruelty with respect to some other animal. So if you're convicted of cruelty with respect to animal A, and you also own animals B, C, and D, those animals would also be forfeited under this provision, except livestock or poultry. Not sure why that is.
So I know you didn't care this. I know years ago when I first came in here, or maybe when I was still on the select board in Norfolk, I know we had animal cruelty with horses
Yep.
on top of, oh my God, whatever hill it is right now. Old Mill Hill or whatever it is, going up 64. Those people, I believe it was kind of a clear-cut case in my eyes.
Mhm.
I believe they took and they moved those, somehow or another, they moved into Northfield. And then they went from there, and I think they went right to Williamstown and continued down the same path.
Hmm.
And I realize horses are different than livestock, but still, did that ring a bell with you either? No?
Not that case, but I would say that if this is kind of similar to what may have happened, that let's say somebody has 10 horses
Yeah.
and they get convicted of cruelty to one of the horses. Under this provision, it's not just that horse that would be forfeited, it's the other 9 also. That's what, so they wouldn't be able to say, move the other 9 to some other place and get out of, or even if they didn't move it, but either way, the other 9 would now be subject to forfeiture, just like the one was that they were convicted of being cruel to.
I think it was all of them. I just want to make sure. So that verbiage is still in there that we've got the whole thing covered
Yep.
right now.
And it's now mandatory, not permissive. Not the court can order that, court shall. Yeah.
So good now.
Maybe just so I clarify for myself, more extreme example would be like someone is convicted of animal cruelty for conduct that they did to like a family dog, but they also own a dairy farm. This would say that if they were if they're convicted, then they would need to relinquish the dog, but they would not need to relinquish the dairy cows that they own in the as part of their operation of the farm.
Yeah, that's exactly the way I would read it.
Yeah.
Yep.
Okay.
All right, so moving on to the next one. This is another one of these sanctions that now is being made mandatory. And that's repaying the reasonable costs incurred by providing care for the animal prior to judgment. So remember, that's before the end of criminal judgment. So it removes that sentence that says what the court has to do if it doesn't order them to pay the cost, because
Where are
it's
we?
no longer an option. Oh, sorry, we're on lines 15 to 18, page 8. Yeah. So this repayment of costs is made mandatory, so you don't need that second sentence anymore. Now on to the next one, number 3. Remember, I mentioned this earlier too. Not only does the court order forfeiture of any animals that the person owns at the moment of the conviction, but any future right to own, possess, or care for any animal for a period not less than 5 years. So under current law, leaves up to the court complete discretion as to how long they're going to prohibit the person from owning an animal, and it's discretionary whether they order that at all. This makes it mandatory and not less than 5 years. So at least 5 years in the future, if the person's convicted, they can't possess other animals. Now we're on to page 9. We've got 2 other pieces here of these sanctions. Number 4, I mentioned this earlier, participate in animal cruelty prevention programs or educational programs, or obtain psychiatric or psychological counseling. So those are now made mandatory. And lastly, number 5, permit periodic unannounced inspection visits by a humane officer, essentially. And so those sanctions are all now made mandatory.
So if somebody went through the cruelty prevention programs or educational programs, they potentially could get their animals back sooner.
That's an interesting point. I'm not sure if the successful completion of one of those programs would necessarily change the length of time that your animal's been forfeited under subdivision 3. I don't see that. So to me, it looks like the way I read it, let's just pick a time so it's easier to discuss. Let's say the court said you can't own any other animals for 5 years. And you have to go through this successful completion of this animal cruelty prevention program. I don't see any connection between those two that the court can then say, and if you successfully complete, I'll make it only 3 years. I think the 5 years is 5 years. But I suppose if it were more than 5 years, because this is just saying that the requirement is not less than 5. So let's say instead the court had said 10, then maybe the court would have the option to say, okay, well, I'm going to bump it down to 5 because as long as I'm going with whatever the statutory minimum is, you successfully complete, I can probably reduce that to 5. So there might be some inherent court authority there, as long as you don't go below that statutory minimum of 5 years.
Representative Richardson, Representative Wilson.
So on page 9, part 4, I'm not aware, and I'm sure we can hear from witnesses about the availability of animal cruelty prevention programs or educational programs, and if they're certified, if there's any quality of them. So that's one issue that I'm wondering about. The other one is it says, or obtain psychiatric or psychological counseling, but it doesn't say specific to animal cruelty. So somebody could go see a therapist about stress or, I mean, whatever, and it would meet the way this looks. It would just, it could meet that requirement. I'm also, I know that there are licensed social workers that practice and are licensed in Vermont, as well as mental health counselors. And so this language is interesting to me because it doesn't necessarily say see a licensed counselor.
Yeah, those are all, I think, legitimate questions to explore with your witnesses in this area and see if you want to ask, like, what kinds of counseling is ordered now? Who does it? And might it be worthwhile to add some language here that's more specific to this type of counseling, that sort of thing?
But it's big enough that it could be an issue. If we add language.
Yeah, I think in other words, I agree with you if you're saying that because it doesn't limit or doesn't provide any guidance about the type of psychiatric or psychological counseling, then yes, it seems like it could be read. One would hope that that's not what the court would do in a particular case, but I think you're right, you could read the language as possibly permitting any sort of general counseling to satisfy the language.
Especially because it says participate, so that might mean go once and get your intake and then check the box off and.
Right.
Okay.
Representative Wilson, do you have questions?
I'm trying to go back in my notes here. There's something about we jumped into a juvenile. And I can't, right here on page 9, on line 5.
Yep.
Court may order the juvenile. Did I miss that before that, where we were talking about a juvenile, and why did we jump over to why did we put that, why is that language in there now? Why wouldn't it have been in there sooner, or it just caught me odd that it's there. I'm not trying to be rough on you. I know you're new with this one here, but.
Not at all. Totally legitimate question, but thank you for the sentiment. I appreciate it. But I think it's obviously paralleling the sentence before it, in that it's talking about psychiatric and psychological counseling. In the instance of the first sentence, it's about an adult who has been convicted of this crime, right? Because that's what this whole list of sanctions that we're talking about only applies. Going back to the intro language on page 8, line 9. In addition to any other sentence the court may impose, the court shall require a defendant convicted of a violation. So this is an adult conviction, generally, that list of 5 applies to. You're right, Representative Gosselin, but first, for a reason that I don't know the answer, in this specific instance only, the counseling piece, there's been a specific addition for juvenile proceedings. And it says, okay, if a juvenile is adjudicated delinquent, Remember, that's a different thing. That's not a person convicted of a crime because that's what all this other stuff applies for. So it's saying, okay, also, in addition to a person convicted of a crime, if you've got a juvenile adjudicated delinquent, which is in the family division, not in the criminal division, then the court may order the juvenile to undergo psychiatric or psychological evaluation, participate in treatment. So it's sort of an added element of a juvenile disposition, someone who's been adjudicated delinquent that would only apply to a child in the family division in a juvenile proceeding.
So you're backed into a couple more things I was going to hit on. So the juvenile, if it's a juvenile, it's going to be looked at much differently than a so-called grown-up, correct?
Well, differently, yeah, in the sense that the proceeding is different, the types of sanctions are different, the proceeding is confidential, you have a case plan, you have a social worker from the Department of Children and Families involved. Yes, all those things are different than a criminal proceeding. Yes. And you don't have a criminal record at the end, the way you do in a criminal proceeding.
And remind me again what age a juvenile is?
Well, at the moment, it is below the age of 19, so 18 maximum.
Okay, now just,
Years.
all right, now let's just back up to page 8, line 20 on where did the not less than 5 years come from? The idea?
No, that was in the, I think your witnesses might be able to answer that, but no, I don't know. That was,
I can answer it if you want.
Sure, go ahead.
Okay, Representative Krasno again for. The original short form bill that I put forward had never again. But, due to feedback from committee members, it was suggested to believe in a restorative justice approach that. So why is it 5 years versus 10? I can't say that, but, personally, I would like folks never to own the animal again, but other folks had felt that it would be fair to not do a forever ban. That people can recover from abuse, but that is a policy decision if the committee decides to change it to a different time, but I had originally proposed forever. Does that make sense?
Yeah, it makes sense, but I also see people and other things where we're doing stuff that they re-abuse or they re-offend and all this stuff here. So the 5 years just
Oh, I
really,
agree.
really coming. So that's good. I'm writing changes too. I feel like a little Eric today.
But yeah, if the committee would like to make it longer or forever, that's in their discretion, but I think some committee members didn't like that, so I had made it softer.
Okay, thank you.
You all set?
Yep, thank you.
Representative Harvey?
Thank you, Chair. This is actually to the bill sponsor. One of the things that I've seen done in this room with different pieces of legislation is almost a tiered approach, right? I mean, like, I agree with you. One offense is one offense too many, especially with regard to the subject matter. But one of the things we could work with you on, if you'd be interested, is either tiered or what do you suggest the 5 years becomes? I mean, I know indefinite, and that would be my view as well, but like 10 years, 15 years.
Yeah, I mean, I'm not a lawyer or expert in the court system, but I'm amenable to whatever the committee decides. That's not, again, you know where my original stance was, because in the short form bill, it was a lifetime ban. But after talking to some folks, they thought that was maybe that people could redeem themselves in different ways through treatment and other things. So that would be, but if you want to make it, I wouldn't want it shorter, right?
Right, no.
Right, I know that's not your intent either, but I personally, as far as I operate in this building, the bill is yours now to make those decisions. I trust the expertise of this committee, so whatever you all think, as long as it's not shorter, here, other reason, I'm not an expert in the court and judiciary sentencing, but, the intent of the bill, one of the biggest catalysts for why I introduced this is because I believe that if you're convicted of harming animals, that one of the biggest problems is that you still can have animals and then repeat offend, which I've seen over and over again, and that is a huge problem, and our state needs to take action. So that's how I feel, but you know that my original intent, because there is the short form, was a lifetime ban.
Lifetime.
On some level, I'm not sure how, maybe we can compare it to some other
Yeah,
laws,
Right,
penalties and crimes, and that type of thing.
yeah.
Representative Oliver and then Representative Arsenal.
I was just gonna ask, is there anything where we hold on the state level crime with someone has completed their sentence that we would hold the behavior against them entirely in its impunity?
Guns.
That's federal. Oh, no, did we pass the
You
state?
did pass it at
We
state
did
law.
pass the state. They
Although you
still
can
have-
get an order of, even in the statute that bars firearms possession, you can get, a relief, petition the court for relief, however, too.
Can you have, somebody say it's a repetitive sex offender, not with animals, have children after they?
Well, you generally be put on for many offenses, you would be put on the sex offender registry, and that would prohibit you from, but again, and that too, as well, I would want to check on
Prohibit you from what?
from a variety of things. But you know, you could, for example, be prohibited from working in a school, things like that, being near children in childcare facilities, that kind of thing. Yep. Now, can you get removed from the sex offender registry, or is it time? That's what I'm not sure off the top of my head, whether it's lifetime or whether for some offenses, it has a finite end to it. I can't recall that. Somebody want to.
I don't know the language around it exactly, but I know people have been removed from it.
I remember that too. I can't remember.
Yeah, but I don't
it's a.
remember the particular.
Yeah.
It's quite.
As opposed to an automatic thing, maybe something you have to petition, maybe, I can't recall.
I don't remember.
I think it's 5311, but I can't remember what it says. I remember the number. It's 5411.
Representative Arsenal, do you have a question?
Yeah, so I was just wondering about this, still on page 9, top of page 9, this number 4. The way that it's broken up by that, the description of the delinquency, in the case of delinquency. The last sentence, the court may impose the cost of such programs or counseling upon the defendant when appropriate. I'm assuming that only applies to defendants, adult defendants.
That's the way I would read it, because the defendant does not typically it's not the term that's used for juvenile proceedings. So I would read it that way.
So I guess the term itself, but I was just thinking, or like,
For clarity.
for clarity,
Yep.
it might help to move that language up. I don't know.
No, that's a good point. You could, for example, you could make a subdivision A and a subdivision B, for example. And move that sentence into a subdivision A after the first sentence. And then your new subdivision B could start with the juvenile sentence.
Yeah.
That way there would be no ambiguity about whether that sentence is, the costs are supposed to apply to the juvenile.
Right.
See what I mean?
Yeah. Yeah, that seems to, I mean, it would be highly unlikely. I would hope to expect that a juvenile would be able to pay for their
Right.
counseling. So just for clarity's sake, I
Sure.
to see it. Order.
Yeah, makes sense.
Representative Oliver, do you have another question?
I know, it sounds a little strange, but just when we start creating something like this, we change, do we need to reevaluate whether it needs to be sealable or expungable? Will it remain that way on its own merit?
You don't have a bunch of anymore.
Well, sealable or available, or, you know, like one of the big 14 or.
Okay, gotcha.
It's a list, so we likely would need to look at the list.
Well, I don't know if it'll fall under the list.
Currently,
I
I don't know.
think we could just look at it and
Yep.
see.
That's right. It's not under the, if you were referring to the big 14 juvenile lists, it's not on that list. But I don't know if that's what you were talking
Would
sealable,
have
so
to
maybe,
be specific to sexual assault or something.
yeah, that's one of them.
Yeah.
That's in the 14, right?
We on to section 5?
Yes,
For the sake of time,
yep,
can we hold our questions until the end? Because we do have quite a few witnesses that are gonna come after Eric.
sure.
And I am planning on a break right at 2:30 for 5 or 10 minutes.
Yep.
Great.
Sounds good. All right. And this one I think I can go fairly expeditiously on. Yeah, so this is the section. So we've gone through the first two items in our big picture, right? Remember that? Kind of thinking back for a second. Item number 1, expanding the definition of sexual conduct. Item number 2 was making these other sanctions just mandatory rather than discretionary. And we're now on to item number 3 in our big picture, which is the cost of care action in a civil proceeding. Remember? So we're not in the criminal proceeding anymore. Now we're in the civil forfeiture proceeding. And when does this apply? This is not, and again, this is separate from the criminal conviction. It can be a parallel proceeding. They can both be going on at the same time, or a civil proceeding could conceivably be initiated. And even though a criminal proceeding wasn't, can go either way. What happens now is that a humane officer, and this is down on page 10, line 2, how does an animal get seized for purposes of one of these civil proceedings? Well, there's really 2 ways. I mean, there's voluntary surrender. I didn't highlight that. That's line 16. That's page 10. So that's always a possibility. The person could voluntarily surrender. But let's say that doesn't happen. Well, in that case, you've got a use of a warrant, right? Humane officer can go to court, get a warrant if they have, very last line, page 10, line 21, probable cause to believe an animal is being subjected to cruel treatment in violation of this subchapter. So as we just went through, there's this long list of what animal cruelty is, right? So if the officer has probable cause to believe the animal is being subjected to cruel treatment, then go to court, ask for a warrant, court can issue a warrant, and they can go seize the animal, right? That's option number 1. Option number 2, page 11, line 9, kind of, it might have been rule 3, seizure without a search warrant. You see that, yeah, see, it specifically authorizes the humane officer to seize the animal without a warrant if, also a parallel to rule 3, if the officer witnesses a situation. So everybody remember rule 3, they're generally speaking, witnessed misdemeanors are subject to seizure without a warrant. But here it's saying if the humane officer witnesses a situation in which the humane officer determines that an animal's life is in jeopardy and immediate action is required to protect the animal's health or safety, then the officer may seize the animal without a warrant. So again, you got emergency life-threatening situation, then you don't have to pause, go to court and get a warrant.
Couldn't you articulate exigent circumstances with the mobility of a dog?
Yeah, I bet you could. Yep. This lays it out in statute for, I guess, so that maybe the officer doesn't have to sort of think of that. I think I totally agree that would constitute exigent circumstances. Yeah. All right. So we know how it is they can seize them, right? Bottom page 11, first sentence, care after seizure, because that's what we're getting at here. The humane officer shall provide suitable care at a reasonable cost. Remember that, Representative Richardson? You were asking about the cost. Reasonable cost, line 17, for an animal seized under this section, and have a lien on the animal. So the humane officer has a lien too. So technically, that's another way they could try and eventually get this money back. Let's skip a little bit. So over to page 12, line 9. Okay, so what happens next? They seize it. They can bring this civil forfeiture action, right? Animals seized under this section, state may commence a civil proceeding for forfeiture, and it's in the criminal division, not in the civil division. All right. They file a motion. Then subsection E, bottom of page 12, lays out what the procedure for the hearing is. You have a preliminary hearing within 20 days after it starts. And, there's various procedural requirements over on page 13. And then I'm going to get to what does the court have to find in order for the order to actually be issued, forfeiting it. That's on page 13, line 10. At the hearing on the motion for forfeiture, the state shall have the burden of establishing by clear and convincing evidence. Now, remember, that is not as demanding a threshold as a criminal conviction, which is beyond a reasonable doubt, right? Clear and convincing. It's more than a preponderance, more likely than not. So it's somewhere between those two burdens of proof. So clear and convincing is what applies, and they have to show by clear and convincing evidence the animal is subjected to cruelty, neglect, or abandonment in violation of those. And those two cross references there, 352, 52A, are the animal cruelty statutes that we looked at a little while ago. Line 14, if the state meets its burden of proof, the court shall order the immediate forfeiture of the animal. Right. So let's say, think about it for a moment. The court does order forfeiture. The state does meet its burden of proof. Well, there was some period of time then, right, where the animal was being held in custody. And during that period of time, it was going to cost money to feed the animal, take care of the animal. Probably if the animal was subject to abuse, good chance that medical attention was required of some kind. So all these expenses have built up. So who pays for that? Who's responsible for those expenses? Over on page 14, lines of 12 through 14. If the defendant is convicted of criminal charges under this chapter, or if an order of forfeiture is entered against an owner under this section, right? That's the civil forfeiture proceeding we just talked about. So if the court says, yes, prosecution, you've met your burden of proof by clear and convincing evidence, this person committed animal cruelty, we're ordering forfeiture, then the defendant is responsible for the money. So the obvious question is, okay, well, the defendant is responsible for the money. How does it collect it, right? Well, there's the existing language is line 16 and 17. The restitution unit within the Center for Crime Victim Services is authorized to collect the funds. Okay, there's an existing procedure for how this would get collected by the restitution unit. So we have the big picture 3, remember, of what this bill does. It adds another method of collecting that money. And that starts over on page 15, line 18. And you see the title of it, cost of care action, right? So that's your third major thing going on in this bill. If an animal, and I'm reading line 18, if an animal is seized under this section, the state or custodial caregiver may commence a civil proceeding for reimbursement of the reasonable cost of animal care, again, reasonable for consideration, and in the unit of the criminal division where the offense is alleged to have occurred. So that's your other thing. And the rest of this language, all the way through to several other pages of the bill, is basically the mechanics of that type of action. How does the proceeding work? So if we turn over to page 16, line 1, it's started by filing a petition for reimbursement. Next subdivision, subsection I there talks about, well, what is the petition that you file have to contain? A subdivision, subsection J, how is it served? Got to be served personally, usually, unless they're unable to do that. Then they can post it on the person's place of residence, sometimes referred as a tack order. I've ever heard that phrase, which I'd never heard it before, because you tack it to somebody's door. I don't know, I didn't know where that phrase came from. So I asked Judge Zoning, what's this tack order all about? It's like, oh, it's because you tack it to their door.
When you first said it, I was thinking horses.
Oh, yeah, right. That's right. That's a reasonable conclusion. All right, over on the top of page 7, court has to have a hearing on the cost of care as soon as possible after the motion or petition is filed. What happens after the hearing? That's further down on page 17, line 15. This is two things I'm flagging for the committee that I noticed as well in this language. The way it's phrased now, upon a showing the animal was seized lawfully and that the cost of care of any animal seized is necessary. So those are the two things that the court has to find, in my view. So I think you might want to think about changing that language upon a showing to if the court finds. The court finds that any animal was seized lawfully and that the cost of care of any animal is necessary. So just think about that, specifically laying out, because I'm not sure, I haven't really, it's a little unusual, that language upon a showing. It's not saying what, on a showing by what? A preponderance, clear and convincing? It's a little unclear. So make it clear. And you might even want to say that. Say if the court finds by whatever, by a preponderance or clear and convincing, for purposes of being consistent with the seizure of the animal. Now that either of them that clear and convincing earlier.
Yeah.
So for purposes of consistency, you might want to be clear and convincing again, but policy decision for you guys. And if that's the case, then the court orders, that's line 18. If the court finds it, or is it showing the animal was seized lawfully, the cost of any care is necessary, Then the court shall order payment into the registry of the court. And that was my second question. I just haven't had a chance to ask Judge Zomey about this, and I see him on the witness list for tomorrow. So you may want to follow up with him about, is that the right place to put the money? Just where it should go. You know, and that may be right, may not be, but it occurred to me as a you want to get that right so that the money's going to the right place. So that's where the money goes, assuming the court makes the finding. Turn over onto page 18. Subdivision 2 there talks about the fact that generally the court does not include ability to pay when it's determining the amount of a cost of care order. So it's about how much care was incurred, how much the cost was incurred, not how much the defendant can pay. That second sentence there, if the payment is not made within 5 days, then the animal is forfeited. So they got 5 days. And this rest of page 18 is interesting. I feel like actually this may respond in some ways to one of the questions you had from one of the witnesses. And they asked about the sort of ongoing nature. Because if you think about it, the court may order that funds be deposited to pay for costs of care, but the proceeding may be ongoing. So in other words, costs are continuing to accumulate. So what you see on page 18 there is sort of this payment structure that every 30 days the person has to pay more if they're incurring more costs. So you kind of keep tabs on it as it's ongoing and continue to make payments if they're found to have committed abuse. So and then the very bottom of page 18, upon payment of those funds, the person may immediately begin to draw from those funds. So they can immediately start drawing it down once it's paid into the fund. And then lastly, over page 19, on the last page, subdivision 6, if at the end of any of these charges, there's still any money left in the fund, it goes back to the person who paid it. So the court, they don't keep it. Last couple of pieces, this is interesting and similar to other places. You've seen this in the criminal law too, that any statements that are made in connection with this civil proceeding are not admissible. That's line 8, page 19, are not admissible in the criminal prosecution. So again, as I mentioned, these are two separate proceedings. There's an appeal right, subsection N. That is actually existing law. It just got moved from somewhere else. So that's not new. It was, oh yeah, there. It's on page 15, line 16 currently. It's just struck from there and moved over to a new place. And that's it. That's what I have.
Representative Oliver, do you have a question?
Yeah.
And Representative Goodenow.
Trying to put it out there or do something. I know from previous experiences having to do with feeding things, if I seize an animal and I put it into the custody of somebody else to take care of it, and they're charging, I'm certain I'm gonna get the bill.
You being a law enforcement officer?
Yeah, well,
Right.
the department,
The department, right?
and the department's gonna be, I'm not paying for it, it's evidence, the state should pay for it. It will turn into some sort of argument. Who's responsible for the payment? Trying to figure that out, because obviously it's not an inanimate object, but an object.
Yep, yep.
For it. Similar to, you know, towing a car, if you take a car for evidence, stuff like that, we have to cover it. Sure.
Yeah, it's an interesting point. It may be that you want to make sure that whoever incurred the cost gets reimbursement. So
Could that be done through victim witness advocacy? I have no idea.
yeah,
I'm just thinking, no.
right. Yep, maybe something that they could do, but it also maybe something that you want to be clear about in the language.
Yeah, Eric, 3 quick questions, I hope quick questions, that are just going to help me as we're hearing from other witnesses.
Sure.
And I'm going to start broad to narrow. Broad one, is animal defined?
Yes. Subdivision 351A, animal means all living sentient creatures, comma, not human beings.
So, for example, I'm just going to use a kind of wild example. For one of the subsections that define simple animal cruelty
Uh-huh.
is 10. Use a live animal as bait or lure in a race, game, or contest, or in training animals in manner inconsistent with 10 VSA Part 4 or the rules adopted thereunder. So like if you had like a fishing contest and you used live bait like worms, is that a violation of subsection 10?
That is the Fish and Wildlife and Conservation title, which I am not familiar with.
Okay.
So I don't know, but I think the way it's written, it wouldn't just be any baiting of a hook.
Oh,
It would be in violation of
It's
Title 10.
10 VSA is referring both to the live animal baiting and the training.
That's the way I read it.
Okay. Okay.
So my suspicion, without having read it, I think it's Title 10 deals with conservation and hunting and fishing and all that stuff, that in all likelihood, someone would have noticed. I was about to say caught it. That would have been a wrong use of that term. Someone would have noticed if they were inadvertently baiting a fishing hook with a worm. It's an animal cruelty crime.
Great.
We do often say nice catch when somebody.
Oh, yeah, that's true. I have said that many times.
Okay,
True.
great. So second question is
Yes.
I want to,
What's the second question?
was
It was.
that the second one?
Yeah, what is an animal?
First one, 4 questions.
Almost.
I've almost exhausted my lot. Okay, in that case, I'll just have one other one. Something that has come up as we've been discussing this bill is an idea around the liability shield for those institutions that take on animals that are seized either in the civil forfeiture hearing, or civil forfeiture sort of track, or in the criminal forfeiture track, or maybe both if they're both pending. If that was something that I were to ask, or we were to hear about from witnesses, is that something that would be appropriate to be put in this bill?
Yeah, absolutely.
Okay.
Yeah, that's right where you would want it. And it may be there somewhere, like, as I say, I don't have the background in this area of the law. When you said it, it just sort of rang a bell. I feel like maybe, but I could have seen it somewhere else. So maybe it doesn't exist. But it might, I'm just not sure.
Okay. I guess I'm interested in that. So yeah, maybe we'll hear from other witnesses on it.
Right. Yep.
So if penalties and expenses aren't paid, can a custodian sell an animal to recoup expenses?
There is some method for that, yes, but assuming that the forfeiture is ordered, or the person is convicted, one or the other, or in the other instance, was it what, if they don't pay, they had a 5-day limit, right? Forfeiture of the animal under the proposal for the cost of care action. If the required payment is not deposited within 5 days, then the animal shall be forfeited. So yes, I think if
5 days.
Yeah.
Oh, okay.
Sure.
Just horses are going through my mind with rescue and that type of thing. And I know that they take in horses and get them healthy and do sell them all the time.
Yeah, I think assuming that they've complied, the procedure beforehand has been complied with, or that the person has went, over their time limit for not paying, then yes, that would be an option. Yeah.
Any other questions for Eric? Representative Arsenal?
I feel like I just don't recognize this language, so I'm looking at page 12, starting at line 9, where it's describing civil forfeiture action, and where it says the state may commence a civil proceeding for forfeiture. A forfeiture in the unit of the criminal division of the Superior Court. So is that just saying commence a civil proceeding in the civil unit of the state of the same court where the criminal proceeding is happening?
Well, in this case, it's not actually necessary that the criminal proceeding is going on because it's where the offense is alleged to occur.
Okay,
So this technically doesn't require that there be a criminal proceeding. It could be. It could be that the criminal proceeding is also being instituted by the state, but It's possible that there's a situation where maybe for burden of proof reasons, they think they could meet clear and convincing, but not beyond a reasonable doubt. Who knows? So, but it could be both proceedings or it could be just the civil. But
Okay.
yes, you're right about the
It's just
location.
establishing jurisdiction,
The venue.
like the venue.
That's what
Okay,
it
I
is,
wasn't, the civil proceeding in in the unit of the criminal division didn't make sense to me, but it's just saying in the civil, on the civil side of the same,
Within the criminal division, it's a civil proceeding, not a criminal.
yeah.
Yeah, exactly. Which is unusual. There used to be more.
They do it with the driver's license.
They do with the drivers, with the, also, I think the DUI suspension,
Yeah.
civil suspension hearing as well. So, because again, you have your criminal DUI case, but there's also a civil proceeding that can go into for your license suspension that also parallel track, lower standard of proof,
Mhm.
also in the criminal division. Same with the DUI criminal cases.
Gotcha. Thank you.
Yep.
Any other questions for Eric? Eric, that was a pretty thorough walkthrough for somebody who wasn't sure if they had it down.
Thank you. I appreciate that. I was a little shaky beforehand. I think you mentioned it earlier, Mike. I'm going to give you the example of how not to do it.
So anyway, committee, what we will do is since it's so close to 2:30, we'll take our 10-minute break now, come back at 25 of, and if we could come right back, so we can get started, as soon as we can, because we do have a number of witnesses, and I would